forum on the revised consent and capacity standards and documentation standards. Please note, this is not a recording of the live event. We have re-recorded the presentation for clarity and timing. My name is Dana Prucci. I am the Director of Professional Practice and Quality Assurance at CASLPO and a speech-language pathologist.
My name is Cassandra Kaminskas, and I am the Audiology Practice Advisor and Manager of Mentorship at CASLPO, and I am an audiologist by training. As a housekeeping note, we've reviewed questions that were asked during the live event, and we are addressing common questions and themes in this recording.
These two standards have been revised to improve clarity to help audiologists and speech-language pathologists better understand and follow minimum standards for consent and documentation. There are no major changes to the standards themselves, which are both based on Ontario laws. For consent, that's the Healthcare Consent Act and the Personal Health Information Protection Act, or PHIPA, and for documentation, it's the CASLPO Records Regulation. The laws are the rules. There are no changes in the laws, and these standards explain the laws. There are standards for consent and documentation in other practice standards because they're of such high importance. For example, in the speech-language pathology intervention standards. These are challenging and essential aspects of audiology and speech-language pathology practice. This e-forum will not be teaching anything new about the Healthcare Consent Act or PHIPA. CASLPO has other available e-forums and resources discussing what you need to know about consent and documentation. This e-forum will focus on the revised standards and what they mean in practice. Let's review exactly what standards of practice are. Practice standards are the bar that all registrants must meet. Practice standards need to be attainable, realistic, current, relevant, be nimble, and apply to all circumstances and practices across Ontario. These standards are based on Ontario laws and regulations, but also evidence from research, practice trends, and changes over time. Practice standards are like the bar shown here. All registrants must at least meet the standards of practice and meet the bar. It is concerning if the registrant is practicing below the bar. That's the misconduct area. It's great to practice above the standards, but all registrants, again, must meet at least the practice standards. Here's a review of the process for revising CASLPO documents. First, the Practice Matters Committee approved revising these two standards as consolidating and clarifying the guidance on these topics would promote consistency for registrants and for professional conduct. These standards were chosen as the previous versions were less comprehensive than the individual standards for consent and for documentation that were within the larger intervention standards. These standards were also chosen based on the number and types of inquiries that practice advice receives. Audiologists and speech-language pathologists consistently have a lot of questions about how to meet standards for consent and documentation. These are also higher risk standards if they're not met, and we identify them as such in quality assurance peer assessments and in the CASLPO mentorship program. These are the reasons why these important documents were chosen to be updated and why we wanted to provide today's education. Next step, CASLPO staff created a draft, including the details and competencies about consent and capacity and documentation that were in the dysphagia standards, and have incorporated them into these standalone documents. The draft was reviewed by the Practice Matters Committee and approved for consultation, and this was the survey that 124 people took part in. The next versions were approved by the Practice Matters Committee and the board and came into effect on September 19, 2025. French and English versions were then posted to the website. Today, we have the e-forum. Next steps are to review questions from today to use them to revise frequently asked questions documents, and we will create and publish a document for the public.
Before we get into the presentation today, we need to review some terms. The first is patient, which is an individual who receives healthcare intervention. This may be synonymous with client or student in the school board setting, or a resident in a long-term care setting. The second term is substitute decision maker. This is an authorized person who is able to give or refuse consent on behalf of a patient who is deemed incapable with respect to intervention. This may be a parent or guardian. For your convenience, we have links to the Healthcare Consent Act, which describes a hierarchy of substitute decision makers. The next term is intervention, which encompasses screening, assessment, treatment, consultation, education, and discharge. Our next term is personal health information. This is information that can identify an individual or can be combined with other information to identify an individual, and it relates to physical or mental health of the individual, including their family health history. It also includes the provision of healthcare to the individual, including the identification of the individual's healthcare provider. Our next term is capacity, which is defined when a person is as a person being capable with respect to a treatment if they're able to understand the information that is relevant to making a decision and appreciate the reasonably foreseeable consequences of a decision or lack of decision. Capacity to consent to a treatment can change over time, and a patient can be capable with respect to some treatment decisions and incapable for others. A person is presumed to be capable with respect to treatment unless there are reasonable grounds to believe otherwise. For example, if there's something in the patient's case history or behavior that raises questions about their capacity to consent to the treatment. Capacity evaluation is a discussion with the patient to determine if the patient understands and appreciates the intervention plan, risks, benefits, and alternatives. This is limited to individual healthcare decisions, admission to a long-term care facility, and support services in the home and confinement. It is important to note that in Ontario, audiologists and speech-language pathologists can evaluate capacity. Capacity assessment is a formal assessment of a patient's mental capacity for decisions about finances and personal care. This is defined in the Substitute Decision Act of 1992. It is important that audiologists and SLPs are aware that they cannot be capacity assessors in Ontario.
So here's our agenda for today. We'll give an update on the content of each set of standards, run through practical scenarios and commonly asked questions that we receive in practice advice, as well as some of the questions that we had at the e-forum recording, at the original e-forum. Let's get started with the revised consent and capacity standards. These standards are an introduction plus the 4 standards. When we talk about consent, remember that it's more than a form. It's the communication about what is being consented to. This may be a discussion with the patient or their substitute decision maker. For registrants at school boards, this could be a letter sent to families where they're told how to get in touch with you. If others are getting consent on your behalf, like administrators or support personnel, you're responsible for ensuring they have the training and competence to get consent, what to say and what to document. There was no introduction in the original standards. Now the introduction refers to the 2 relevant acts and the essential components. Consent is highly governed by the laws, the Personal Health Information and Protection Act and the Healthcare Consent Act. We'll go into more details on these principles of these acts. When obtaining consent, registrants must ensure patients and relevant others understand what they're consenting to, provide opportunities to patients and relevant others to ask questions, inform patients and substitute decision makers that knowledgeable and informed consent can be withdrawn at any time, consult with the SDM when the patient is deemed incapable to provide consent, and ensure the person obtaining consent has the relevant knowledge and training. You are ultimately responsible for ensuring that informed and valid consent were obtained and documented. The first standard is about knowledgeable consent, and it says, registrants must obtain and document knowledgeable consent from the patient or substitute decision maker for the collection, use, disclosure, and retention of personal health information, and this refers to PHIPA. The original standards listed the 6 criteria for Circle of Care. In these revisions, these have been removed and a link added to the Information and Privacy Commissioner of Ontario, since it's their term. The idea to obtain and document was added to this standard as well. The Personal Health Information Protection Act is administered by the Information and Privacy Commissioner of Ontario. There are great resources on their website. In a nutshell, PHIPA protects personal health information. The Act establishes rules for the collection, use, and disclosure of personal health information about individuals. The Act also covers the patient's right of access to their personal health information upon request and to correct personal health information if the record is incomplete or inaccurate. We have a recent CASLPO practice advice document on understanding personal health information that we wanted to draw your attention to as well. These are the relevant sections from PHIPAA. Essentially, consent for collection, use, or disclosure must be from the individual or their substitute decision maker, must be knowledgeable, must relate to the information, and not obtained through deception or coercion. For consent to be knowledgeable, the individual must know the purpose of the collection, use, or disclosure, and that they can give, withhold, or withdraw consent. Standard 2 is on informed consent, and it says that registrants must obtain and document valid and informed consent for each step of intervention, that is screening, assessment, treatment, consultation, counseling, and education. And this refers to the Healthcare Consent Act. Obtain and documenting consent has been added. The Healthcare Consent Act includes the 4 elements of consent and required information that the patient or substitute decision maker must be given, and these were included in the information under the standard. Let's highlight these key principles of the Healthcare Consent Act. There are 4 elements to informed consent. They must relate to the information, be informed, be given voluntarily, and not obtained through misrepresentation or fraud. For consent to be informed, it must include the nature of the service, the expected benefits, any material risks, any material side effects, alternative courses of interaction, and likely consequences of not receiving service. Although the Healthcare Consent Act does not define the meaning of material risks of the treatment or material side effects of the treatment, it's likely that they include those which are probable or likely to occur, those which are possible if they carry serious consequences, and those which a reasonable person in the patient's specific circumstances would require in order to make a decision to give or refuse consent. General principles of the Healthcare Consent Act include that before proceeding with treatment, audiologists and speech-language pathologists must believe the patient is capable. If the audiologist or SLP evaluates the patient's capacity and determines they're not capable, then consent must be obtained from the substitute decision maker according to the SDM hierarchy. Patients in SDMs have the right to refuse, withhold, or withdraw consent at any time, and ODS and SLPs must respect patients' decisions, even if they do not agree. ODS and SLPs do not need to get consent when variations or adjustment to the care plan are not significantly different. An example for school board speech pathologists is that if the care plan in the previous school year has been picked up again in the new school year, the law suggests that you would not need to obtain new consent. However, in practice, it may be a good idea to check in with families about the initiation of the new service delivery, or it may be required by the school board's practices and protocols. If the intervention will be the same, but in a different setting, obtaining consent again is not needed if there will be no significant changes to the benefits or material risks. Standard 3 is on capacity to consent and says that registrants must evaluate capacity if the ability of the patient to consent to their services is in doubt, and we've added more information to this section. Evaluation of capacity could be an e-form all on its own, and we'll discuss it briefly here. A person is capable with respect to a treatment if they're able to understand the information that is relevant to making a decision and appreciate the reasonably foreseeable consequences of a decision or a lack of decision. In Ontario, the presumption of capacity applies to everyone, including minors. There is no specific age of consent. We have some resources on evaluation of capacity. One is the CASLPO Practice Advice FAQs on evaluating capacity and consent. If the guardian, as a substitute decision maker, has provided consent for a child's assessment or treatment, you do not need to have a consent conversation with the child. However, depending on the maturity of the child, you will include them in therapy activity choices to maximize participation. If you believe the child or youth can understand the assessment or treatment plan and can appreciate the consequences of their decision to participate, then you would obtain consent from them. A registrant on the survey said it well. Evaluating capacity in an individual who has a communication disorder can be especially challenging. Audiologists and speech-language pathologists are in a unique position of understanding that a patient's hearing or communication can impact their ability to demonstrate capacity. Thank you for this important contribution during the consultative process. Standard 4 is on documentation of consent. Registrants must document every consent received. Basically, if it's not documented, it's like it didn't happen. We've added information to this section. You need to document the consent and the conversation, but also documentation of clinical reasoning for allowing a minor to consent. This would be beneficial and allow for increased accuracy in documentation. Please review CASLPO's records regulation for a fulsome review of what is required for record keeping as a CASLPO registrant.
I'd like to discuss our first frequently asked question. Does consent for services expire within a specific time frame? The answer is no. Consents do not have any identified legal time frame. However, your workplace may define a period of time during which they consider consent to be valid. In these situations, you may be required to obtain consent. Under the Healthcare Consent Act, you may presume that consent to services remains valid as long as the nature, expected benefits, material risks, and side effects are not significantly different from the original treatment. If there is a significant change to the plan of care, a new consent needs to be obtained and documented. You're always expected to use your professional judgment. If it is apparent that the patient needs a review of the elements of consent because this is not fresh in their mind, review the elements of consent and required information with the patient or their relevant others to ensure that consent is informed and valid. You are always expected to use your professional judgment in these situations.
Another frequently asked question is, do we need consent to record sessions during intervention? You will need both consents: knowledgeable consent to collect, use, disclose, and retain the recording during an intervention session, and you'll also need informed consent, which would be explaining the purpose of the recording. The majority of registrants are already appropriately getting consent as required, but we added to the description of the standard, where it says that recordings of patients and consent for others to take part, such as support personnel, students, volunteers, and interpreters. It's time for our first scenario and poll. While it's about speech therapy in school, the principles apply to all practices. Remember, knowledgeable consent is a requirement under PHIPAA and the records regulation. Informed consent is addressed by the Healthcare Consent Act and speaks to the intervention and services being provided by the audiologist or speech language pathologist. Sophia has approval for an assessment and possibly therapy for a student in grade 2. Sophia already has the case history, knowledgeable consent, and communication concerns from the intake form. Does Sophia need to talk to the substitute decision maker or to the student first? Who does Sophia get the consent from? So you can think about it. Does Sophia need to talk to the substitute decision maker first in order to get informed consent? Must she talk with the student first in order to evaluate their capacity and then get informed consent? Maybe she should talk to the SDM first in order to get a sense of their concerns, or speak with the student first to see if they prefer to miss recess or class. Or Sophia must talk with the substitute decision maker, but I'm not sure why. Practice advice gets this question often. In other words, when assessing a child, do we need consent from the SDM or the child? Does saying children have capacity mean we could provide intervention to the child without consulting the substitute decision maker? The substitute decision maker, likely the parent or guardian, provides the initial consent. You won't know if the child has capacity to consent until they're sitting in front of you. You need consent from the SDM to start. Registrants always need to continuously evaluate a patient's capacity. Remember, the definition of capacity is to understand a decision and appreciate the consequences of the decision. Your workplace may have additional stipulation on when consent is required. Consent has different levels. Overarching consent would be the parent or guardian. To do a specific activity could be the child. And you really want to wait until you meet the child. Remember that a 2-year-old refusing to take part is not withdrawing consent because they do not have the capacity. Overall, consent is not age-related.
I'm taking over a patient from a colleague. Do I need to get new consent to treatment? The answer is not necessarily. The paragraph shown here highlights what is said in the Healthcare Consent Act. What it means is that if you're taking over and continuing a plan of care, audiologists and speech language pathologists can rely on the consent already obtained, and new consent is not required. If making changes to the previous intervention of service delivery that involves new information, you must communicate with the patient or the substitute decision maker and get new consent. Audiologists and speech language pathologists are responsible for ensuring that consent is valid and up to date. For resources related to capacity and consent, please visit the CASLPO Consent and Capacity website or webpage. On to our next scenario. Gabriel, an audiologist, supports a patient in a long-term care facility. The patient lost their hearing aid last week, and the patient does not have capacity to consent to replace the device. Gabriel has not been able to contact the patient's substitute decision maker. Should Gabriel immediately replace the patient's lost device? Let's consider our possible options. Yes, the patient's cognitive function is at risk. Or yes, the patient is not able to communicate with others without their hearing aid. Another option, it depends. Is the substitute decision maker usually accessible? And finally, no. Gabriel requires the substitute decision maker's consent to proceed. And the answer, the audiologist must try to speak with the substitute decision maker. Audiologists must also check if the hearing aid has loss and damage coverage. If there is loss and damage coverage and there are no additional charges to the patient, the audiologist can proceed with ordering the device. They should upload the most recent fitting history and document services provided in the patient's file. Documentation should highlight the clinical rationale for the provision of services and that all attempts to contact the substitute decision maker to date were unsuccessful. This information needs to be documented because this is a deviation from the practice standards. Please note that the audiologist will need to continue to try to speak with the substitute decision maker to provide an update on care received. In contrast, if there is no loss and damage coverage and you do have loaner stock available in the clinic, it can be fit while attempting to contact the substitute decision maker. Effort should be made to match the make, model, fit, and prescriptive targets to the device that was lost. Registrants must also document in the patient's file that this decision was in the best interest of the patient and all attempts to contact the substitute decision maker to date were unsuccessful. Before fitting the device, registrants must ensure that appropriate infection control practices have been performed. On to our next scenario. A patient has contacted you regarding a simple change to their hearing aid settings. You suggest connecting their devices virtually via the manufacturer's proprietary software application. What must you discuss with the patient beyond the typical knowledge and informed consent elements? The possible answers are: the patient must appreciate what information is shared with the manufacturer, or the patient must understand that they can withdraw consent for this service through the manufacturer's proprietary application at any time, or the patient must understand the manufacturer's data storage and housing requirements, for example, AWS2, SOC, or GDPR. Our next possible answer is nothing. The knowledgeable consent elements are already covered by the application. And lastly, everything that was highlighted above. The knowledgeable consent elements are inclusive of everything previously discussed. Answers A and B may seem similar to the elements of knowledgeable consent, but you need to be aware of the fact that personal health information in this case is also being shared with the manufacturer. You as the audiologist are not the agent or the HIC in the workplace. And so you must make sure that the patient appreciates that their information is being shared with another party. Patient knowledge of the manufacturer's data storage and housing requirements does not necessarily apply. This would only apply if the patient specifically asks about it. Therefore, you as the clinician need to be aware of which regulatory requirements apply for a particular manufacturer's software agreement to ensure the protection of personal health information that you share with the patient. As the audiologist, you need to have knowledge regarding legislative protections and data storage requirements for personal health information.
Here's another frequently asked question. I'm a speech-language pathologist in a school board where I assess students. The therapy plan is carried out by the support personnel, such as a CDA. What information needs to be shared with the substitute decision maker to obtain consent? The answer comes under Standard 2, informed consent. In addition to consent for the proposed intervention, consent is needed for the support personnel to be involved in the therapy. Patients and substitute decision makers need to be informed of the role of the support personnel versus the role of the speech pathologist, what aspects of the intervention the support personnel will provide. They need to know that the speech pathologist is ultimately responsible for the intervention, and they need to know about their right to decline the support personnel's involvement. Another question is, I work with children and my patient's parents are divorced. One parent has consented to intervention, but I have not been able to contact the other parent. Can I proceed with intervention since I have some consent? The answer is, it depends. We have questions on this in the CASLPO document Consent and Capacity FAQs. First, you must confirm who has the authority to consent to services. If both parents have authority to consent to services, you will need to obtain and document consent from both before proceeding with the intervention. The care team should confirm ahead of time who has the authority to consent to intervention. And this could be you, the audiologist or speech pathologist, a social worker on the team, support personnel, administrative staff, etc. In some situations, you may also want evidence of this authority. You may ask for the custody agreement. Overall, take what the guardian tells you at face value. This is the same answer as if it's an adult patient who does not have capacity, but their adult children who have power of attorney do not agree on the intervention. You cannot proceed without consent from both of them. The point is that you can be held at fault for not getting consent from someone who has the legal authority to give it. You always want to document all consent discussions in the record so that you have proof and evidence of what's happened. This question is on implied consent. I performed dysphagic evaluations in acute care and relied on implied consent, where the patient cooperates with oral trials during a clinical swallowing assessment in order to determine appropriate diet textures and route for medication administration. Is this acceptable? Only if the consent is informed. You always need to have the informed consent conversation with the risks, benefits, etc. with the patient or substitute decision maker before proceeding with the intervention. The intention of the Healthcare Consent Act is implied consent is only after all the other requirements for informed consent for treatment have been met. Patient or substitute decision maker must have received all the information on intervention. Implied consent is an option for patients to convey consent. It doesn't change the expectation of registrants. You still need to give them all the information to make a decision and consent to the intervention. It's very rare that speech-language pathology services would be considered an emergency as defined in the Healthcare Consent Act, especially if there are non-oral alternatives available for nutrition, hydration, or medication administration. Again, for consent, the laws are the rules. We have lots of resources available on the CASLPO website, including e-learning, position statements, practice guidelines, practice advice, like understanding personal health information. There's also the Health Profession Regulators of Ontario resources that were created, and frequently asked questions. And we encourage you to go to the Information and Privacy Commissioner of Ontario website as well.
So we're going to take a look at some of our frequently asked questions that came during the original recording, or sorry, the original review of the e-form. The first question is, how do we manage if a child has capacity to provide consent, but the parent does not agree that the child does not want to proceed with services? For example, a teenager who stutters and doesn't want treatment, or a teenager who does not want to wear their hearing aid. Dana, would you like to provide a comment on this?
I'm going to say I'm very happy to answer this one. So if a child has capacity, then whether they give consent or do not give consent, that decision must be respected. So I'd like to give the example of my daughter when she was 9 years old, needed to have occupational therapy in school. And I will also point out that I have consent from my daughter to share this story. So as part of the assessment, the OT completed a capacity evaluation on my daughter and called me at the end of the day and said, I've determined that she has capacity to understand and appreciate, but she did not give consent, so we're not going to be doing occupational therapy. And I had my parent hat on and I said, that's ridiculous. She's a child. She can't consent. You need to do it. And the OT reiterated that the child, my daughter, has capacity and did not give consent. And so I had to put my SLP hat on and realize that she absolutely did have capacity consent or not consent, and that we had to respect this decision. Although we did have a conversation later that day when she was home from school to talk about what it meant. And she already knew this because the OT had gone through it. Another question that we had was, can we have some kind of printout outlining all the possible risks and benefits of all possible procedures at the clinic for patients to read and sign during intake as an option? So again, consent is about people receiving and understanding all the information they need. What the patient or SDM is consenting to needs to be clear, and you need to communicate the information to them in a way that they'll understand all the elements of consent and that they have the opportunity to have their questions addressed. How you do this is up to your professional judgment, but they need to get all the information in a way that's clear.
So our next question, if a client has not consented for some aspect of care, and then later the client gives verbal consent for that aspect, is documented verbal consent acceptable for the change, or should you get a written version of the consent as it's still visible in the client's or patient's file? The response is that both verbal or written forms of consent are appropriate as long as this is documented. It's not about the form itself, it's more about the conversation, and whether that happens in an oral or written format, it doesn't really matter. There's no specific requirement under the PHIPAA or Healthcare Consent Act or in our standards at the college that consent needs to come in a written form.
Yes, I agree. And so even, so if you're getting consent again, it needs to be documented no matter what the first form says. Okay, so let's move on over to documentation standards.
The revised standards consist of an introduction and 3 standards. Again, we won't have any scenarios in this e-form for the documentation standards as we're focusing on the standards themselves. Please refer to other e-forms found on our website, including the one on record keeping and tips. Documentation is a cornerstone of clinical practice and healthcare. We cannot overemphasize how important accurate documentation is. Documentation can be paper-based or electronic. It can include the report, but it really is about your clinical notes as well as the report. You must appreciate that the health record is a legal document. As a legal document, it must identify what you as a healthcare practitioner did and why you did it. The health record must be comprehensive enough that it captures the care you provided. In evaluating whether your documentation meets appropriate standards, you might consider records from a few different perspectives. You might ask yourself questions from the clinician's, patient's, and regulator's perspective. From the clinician's perspective, you might ask, what if I win the lottery and stopped working tomorrow? Are my records capturing information on what has happened to date and the consent that has been obtained? Do my records have enough detail to allow someone else to pick them up and continue the intervention? From the patient's perspective, if the patient asks to see their records today, could I provide it to them and be confident that it clearly and accurately depicts the services provided to date? Lastly, from the regulator's perspective, if I were the subject of a complaint, do my records support the care that was provided, the rationale for my clinical decision-making, and all other relevant information about the care that has been provided? As we mentioned during review of the consent and capacity standards, if you didn't document it, it's like it didn't happen. The introduction in the original documentation standards was brief. The revised introduction is now more fulsome. Just like the consent and capacity standards, there is no change to current legislation as it relates to documentation. However, these standards have been reviewed and revised to increase transparency and clarity for registrants. The original standards did not have descriptors for documentation, for example, complete and accessible. These qualifiers were used in CASLPO practice advice documents and FAQs, but they belong in the standards as well. Records that are complete and accurate demonstrate clinical judgment and reasoning, accountability, and risk management. Standard 1 pertains to documentation of intervention. Registrants must document all aspects of intervention. This includes screening, assessment, treatment, consultation, education, and counseling. The original documentation standards had one standard saying to document all aspects of the provision of services. There was a separate standard, Standard 2, for documenting communication and collaboration. However, This is all part of documenting intervention, and it has been combined into the revised standard as Practice Standard 1. Please note that the new revised standards highlight that registrants are responsible for addressing issues that arise with their record-keeping system or their ability to complete documentation according to standards. This may include proactively addressing concerns and/or seeking assistance from an employer or a colleague. Registrants can also speak with CASLPO practice advisors when assessing what they might need to discuss with their employers as it pertains to documentation in the patient health record. Standard 2 relates to record storage. Registrants must ensure that records are securely stored and confidentiality of patient personal health information is maintained. This particular standard refers specifically to the Personal Health Information and Protection Act. Standard 3 relates to the fact that records need to be maintained and be up to date. Registrants must take all reasonable steps to ensure that the patient's records are up to date, accurate, and complete, including when providing intervention with other service providers. This revised standard has added more information to this section. Previous standard highlighted that you need to work with other practitioners in your healthcare team. The revised version of the standard highlights the importance of providing intervention services collaboratively in the context of the healthcare system. This means that documentation must include collaboration with service providers who are both a part of and outside of your immediate healthcare team. Additionally, records need to be available for the patient to access upon request as per legislation under PHIPA. For clarity, this does not mean that the patient needs to be able to access the report. It means that they need to be able to access the record itself. For example, if you use SOAP notes, these need to be accessible to the patient. On to our next frequently asked question. How does CASLPO want me to document emails in the record? For example, do I print it out, copy it directly, or summarize it? The answer is that every professional interaction, including attempts to communicate, need to be documented in the record. How communication is accurately reflected in records is a workplace decision. This refers to Standard 1, that all aspects of the intervention need to be documented. To our next question, how quickly do we need to complete the patient record? The answer is in a reasonable time frame. We understand that registrants want a concrete answer, for example, 5 hours. The reality is that professional judgment must be taken into account when considering the risk of harm to the patient if the record is not accessible. This is true for any aspect of the record, such as SOAP notes or reports. For example, a swallowing assessment in a hospital needs record completion within the day. If you are a member of a healthcare team, others are reliant on your records. In contrast, a motor speech therapy session for a child doesn't have the same urgency. In audiology practice, the report related to a sudden hearing loss is more urgent than a hearing aid evaluation report. If CASLPO were to give its registrants a concrete answer like, records must be completed within 5 hours of service delivery, this would not allow for the use of professional judgment in considering the factors that are relevant to the registrant's workplace and service delivery model, as well as the urgency of the patient's care needs. Providing this concrete answer would not be appropriate for all registrants. It may also set an unattainable expectation of the profession, which is not the purpose of a practice standard. However, according to PHIPA, if the patient asks for their record, you have to respond to access requests within 30 days. Please note that your workplace may have specific policies or rules around when records need to be completed.
Our next question is, what if my workplace isn't aligned with the CASLPO standards? Let's think back to that image of the practice standard as a bar. As a CASLPO registrant, you must follow standards, and your practice must be at or above that bar, even if your workplace requirements are below. You have to follow practice standards and legislation to ensure the safekeeping for personal health information in all workplaces, regardless of whether you work in the private or public settings. This includes where personal health information is stored and for how long. If you have questions or concerns about meeting minimum practice standards in your workplace, please contact CASLPO practice advisors for additional insights.
On to our last scenario, which is about electronic records being implemented in the workplace. AKE has always been able to keep up with clinical records until their workplace switched to a digital system. They found the new system confusing and prefer to maintain paper files instead. Can AKE keep paper files when the workplace is using electronic records? Our options are that AKE can keep using paper. It's been acceptable and uses AKE's professional judgment. Or AKE should ask for support to document in the electronic health record. Alternatively, AKE must immediately stop using paper files and only use the new system. Another option would be that AKE should make a real effort to use the new system and block more time in their schedule for documentation. Our last option, AKE should make a real effort to use the new system but keep documenting on paper until they are comfortable with the electronic record system. Our answers are AKE should ask for support to document an electronic health record, and AKE should make a real effort to use the new system and block more time in their schedule for documentation. In this scenario, there could be a time or a period of time where AKE is working both with the paper-based and electronic record formats. It may be appropriate to keep paper records while learning how to use the electronic record system. To ensure the continuity during a transition over to a new electronic system, you should speak with your leadership team and determine if you can copy or scan your paper-based notes into the electronic system for a brief period of time. As you learn to work with the electronic system, consider developing a learning goal and completing clacks on point-of-care documentation or whatever other learning will help you in developing the skills needed to effectively use the new system as part of your practice. You might consider seeking support from peers, the IT team, your supervisor, and/or the leadership team. You might ask the leadership team if they will let you decrease your workload temporarily while you transition to the new system. From Standard 1, registrants are responsible for addressing issues that arise with their record-keeping system or their ability to complete documentation according to standards. This may include proactively addressing concerns and/or seeking assistance from an employer or a colleague. This means that it could be considered to be misconduct for not completing records and blaming the electronic system. If you need help with the system, speak with your employer or a colleague early on. Ultimately, you must know how to document in the system in place at your organization. It is not acceptable for you to say that you don't understand the system and therefore you cannot document what's going on in your service delivery plan. You need to remember that the laws set out in the legislation are ultimately what you must follow as healthcare providers in Ontario. CASLPO has several resources related to documentation to support you in interpreting the legislation. We have the position statement on the disclosure of test materials, practice guidelines on SLPs employed in the school board setting, and several practice advice documents for your review. Now we're going to return to some of the questions that were asked during the original e-form. It was noted that we had themes about what, sorry, just a second. We had specific themes related to calls for patients, booking appointments, and whether or not they needed to be documented. As outlined previously, every professional contact needs to be entered. You need to remember the purpose of records is that it serves as a legal document. For example, if you need to discharge because of workplace rules that there are no responses from the patient in attempts to contact them to date, you need to demonstrate that those attempts were made. You need to document all professional contacts for reasons such as these. Dana, did you have anything else you wanted to add?
No, I think we had lots of questions about that, and you're right, Cassandra. It really is. Think about documentation as a legal document. It shows your clinical reasoning, and it's something I really like how you said before about thinking about it from 3 points of view: from clinical perspective, from the patient perspective, and then also from the regulator, that it could help you if something ever comes up in conduct. So I think that takes us to the end of the presentation. We had lots of questions, but they were very much along the themes that we dealt with today. So hopefully this was helpful to anyone that's watching this. If you do have any questions about consent, capacity, or documentation that weren't addressed today, please don't hesitate to reach out to Practice Advice. Thank you.